I hope you're well.
Sena.
Yes, this is Sena. This is Sena.
Okay.
It's been quite a while since we spoke. Let me start from a question asked by someone who is following us on Facebook. So I just want to ask all those callers who are lamenting, what stops them from writing another petition on all of the issues, perhaps, where the Chief Justice held the opinion that no prima facie case has been made? Can you send another petition on the same issues?
Yes. If you have evidence or different evidence, let's say so. So maybe the thing where we should start from is that we should publish all the petitions that were dismissed, and then we'll publish the decision of the Chief Justice, so that then we can analyze. That would help immensely. Otherwise, like we are groping in the dark. We are groping in the dark because now we don't have the material, so the analysis is extremely limited. We are not able to point out what Chief Justice saw and what he said on each point. So the first starting point is that publish the petition, then publish the Chief Justice ruling. You remember when Akufo-Addo dismissed the petition against the Kweku Asare petition, Professor Azar? Yeah, Akufo-Addo published his ruling, very lengthy. Yeah, we took time and read everything. Yes, then we could see where we agreed and where we faulted. And it's good because the foundation for these publications, etc., have been laid already in the Supreme Court case of Justice Berry and others, versus Tiger PI, Attorney General, etc., where the Supreme Court said after the hearing, the secrecy cloak is broken or is taken away. So this one, the prima facie, is also a type of, it's a preliminary hearing, so it has concluded. So no more secrecy for the EC's petitions. And even that Justice Berry case was about 146. So that's a matter of the EC. But when it comes to the Special Prosecutor, when you look at the Special Prosecutor Act 959, there's no provision for in-camera hearing. So presumably, his can also be published. So let's publish all the three petitions. Let's publish what the Chief Justice ruled. Then it can help in the analysis.
And helping, and because aside that, everybody who perhaps is thinking of petitioning on the same matter may also be wondering, what did these people argue that led to the Chief Justice making the decision he made? Because when I read the Sandro Kofi Akpafulolobi conclusion, I was of the opinion that perhaps it would be difficult to convince the Chief Justice. Is that why you're asking for the publication, perhaps to guide future petitions as to where they failed?
Absolutely. And then also we can decide whether we agree with the Chief Justice or not. Yes, we also have a right to disagree with him. So it's law. So he will show us in his ruling, you see which laws he relied upon. Then we see whether we agree or not. This democracy, we have long insisted on such things. It's not like those days where, once a big man is spoken, that's it. No. You can see that from 92, the number of our citizens who are trying to hold public officers and duty bearers to account has been increasing. So you see that gradually we are becoming more assertive. So lawyers who want to read, and it's not only lawyers, lay people. There are some lay people, they even help us in their argument without reading law. Some of the arguments we hear on radio, they say, it's like a legal argument, but the person hasn't gone to law school. And it's not only law that we use for their argument. Sometimes the arguments we use come from other courses, psychology, sociology, etc. Let me show you one example that recently brought trouble. When I say trouble, like disagreement. So I said, in psychology, there's what we call negative bias, where simply put, the human mind tends to remember a lot of the negatives rather than the positive. So I said, based on negative bias, when you bring Dr. Bawumia, people will remember all the bad things that went on during the Kwadu. So on that basis, I was making the point that the MPP should bring a fresh candidate that will not have, people will not get many things to talk about, so like Patrick Wama, etc. Then you are like, no. How can I say that? So the point is that I have to say that it's from psychology. You can interview psychologists and ask them that yes, if you don't want to interview them, Google it. Is what is negative bias, and you see the research done around it, etc. So the point I'm making is that the arguments we use in court and on the various programs, they are not always fully legal. Sometimes there are other courses, different courses, from archaeology to zoology. So citizens can weigh this. When you see what the Chief Justice is written, maybe an archaeologist will see something and say, no, that's not it. It's rather this perspective. And then it helps to move our democracy forward. Because democracy is crowned with wisdom. Yes, some of the things may be unpalatable. When you hear them, you cringe and the rest. But even in the ugly noises, there's wisdom. The more you cringe, then the first lesson you'll be learning is that then we need to give our people good education. Because the more we educate them, then the less would have such extremist or very ignorant views. If it's not educated your citizens and they are giving you all manner of opinions, you learn from it that you need to give a speech. Yes, so publication, sunshine, like they say, is the best disinfectant. Let's publish the petitions and publish the ruling. Then the analysis can properly go on.
But even before you get there, do you have some opinion on the dismissal of the petitions in themselves?
That's what I said. So, Rana, it's likely to be just emotional because I've not seen. So, you see, I also cannot pretend. When I say I cannot pretend, what I mean is that some of the petitioners had made some points before they put in their petition. So I think from the way that my mind works, I thought that, they would win. So let me give you one classical example, I said, from each side. So when you start the Special Prosecutor, so there's Apostle Abraham Lincoln Lad. At least the day we went to support him on his one-man demonstration, one of the things he said was that he was extremely pained that Kise Jabe had said he went to NID, didn't get help to arrest Oforiatta. He went to National Security to seek help to arrest Oforiatta, didn't get help, etc. But I turned out before. So based on that, he, Apostle Abraham Lincoln Labi, wanted Kise Jabe to be removed. So that is one ground that, it's something I have strenuously argued. I've also written to NID, etc., where they deny. Because where a public officer comes out run down other public officers. You know how the mention of NID, that's previous DNI. DNI, the DNI that when you hear they say when they invite you come to DNI, it's like cry. That they say the bastardized DNI, say them let's cry. You see, so where you have one public officer running down other public institutions like that, it's a very serious matter. It's not a child's play. So equally, he added that. That's why I said, then let's publish the petitions because I'm talking about what he complained about. I'm not reading from his petition because I don't have what he presented, right? So because of that, the best is that let's publish, then we'll see what is inside because this thing he could articulate well. If only it is in his petition, I'm wondering how that was displayed. The man, because when you read the Special Prosecutor Act, he said it even has another ground for removal where it stated that when his conduct brings the office into disrepute. Let me see, is there act here? Let me try and read it. Yes, wait. Where the conduct of Jabe brings the office into disrepute, it's a ground for removal. It's removable for such a thing. Let me see. It's section 15. Just hold on. Okay. Yes, so look, it says that section 15, 1C, conduct which is I brings or likely to bring the office of Special Prosecutor into disrepute, ridicule, or contempt. So when the big man has been caught lying like this, and people are poo-pooing the office of special prosecutor, etc. Straight, this one is disrepute. And this argument is not going to end today. When my petition is dealt with, we will come back again to it. And for the rest of the decades to come, this argument is on the internet. It will be there that the special prosecutor went and said these things about other state institutions and he's keeping his office. No, it doesn't happen like that. Okay, so the ground where I was advancing, your question was that, oh, do I think that he could win, right? I mean, I'm paraphrasing your question. And I'm saying that based on this thing that he said, though I've not seen the petition, based on the argument that Apostle Abraham Lincoln made, that Jabi had lied about NIG, national security, etc., he should go. It's a strong point. So if it is in his petition, I think that should move the petition forward. So once again, how we'll end it is that let's see the petition, then when we see the ruling, then we can properly firm up the argument.
And one last question to you, just for the purpose of education. Are you clear in your mind as to what guides the Chief Justice in making this decision? Because we are also wondering what the standard of proof has to be. Because I am also looking at the Sao matter and thinking it should be an easy case to make.
Excellent. Well, I said I'll do one example from both sides. So the Sao matter is the argument I would have made against the issue, because that one we heard some of the petitioners complain about that sound, right? Yes. So in terms of what guides the Chief Justice, the law, as far as I understand it, is that the prima facie means that what you put in the petition, are they straight, strong enough that when somebody reads them, the person sees that, oh, this is very clear, and so it must require an answer from the EC. So remember, prima facie is not like evidence-based sales. No. If it's sufficient to require another person to answer, so like with this EC thing, the argument is that the EC didn't do enough to be able to make sure that South took part in the election. This is, even without straight away looking at all the evidence, it's a serious matter, because this involves the lives of over at least 100,000 people, if not millions. But I know that the South communities, when you put them together, there will be hundreds of thousands, right, who didn't get an MP. So how can such a thing be written that the EC has no answer at all? EC doesn't have to answer. This thing, you see, me myself, it baffles me. So the best way to remove the baffling, the surprises, the shocks, etc., is that let's see what the petitioners wrote, and let's see what the Venerable Chief Justice wrote. I'm sure with that, and then we can make proper arguments. Yes, even if I can understand that, look, on the ground, the Chief Justice has a lot of things to do. So elsewhere this morning, I was arguing that perhaps maybe it's about time we reconsidered the matter of making the Chief Justice, of involving him in such petitions, etc. Because it's a lot of work. The courts are took administration, so it's a lot of work. So with this, sometimes you know that the process is slow, because all these petitions, right? If you even look for the OSC ones, the Chief Justice is required by law to come out with a decision within 30 days. Okay, within 30 days. We couldn't follow that because they're busy and all that. So the whole place, what I see is that we need to sanitize the system about these petitions and how the rulings should be delivered, because the rulings must be delivered and they must be published like what the Kukwado did, because it helps so that we all can read and understand. When you give a decision and the people don't see the reasons, etc., it creates a lot of distrust. And even the Supreme Court itself so held as far back as 2003, 2004. That's one of the Chachikata cases where they said when a judge makes a decision and doesn't give the explanations, etc., the reasons, then the person will come before the court, feels like the judge, the judge just said anything. There is bias, there is malice, etc. All right? Lack of thoughtfulness is thoughtless because the reasons have not been given. So this Supreme Court decision as our guide, we will need to sanitize the system so that there will always be well written out reasons. If let's say we cannot give out the reasons immediately, like the way as I've said, practically I know how the Chief Justice took with so much work and awful. Yeah, we'll give timelines that okay, at least by so and so date, the written reasons should be given. Or in this case, if it is that they've been given to the president should release them. Because if we don't read the reasons, look, the fact that this matter will go off the radar in the next 3, 4, no, okay, let's say after Saturday, because I'm sure on Saturday we'll discuss this, and then maybe Monday, last interview. So let's say it's long and short. The fact that this matter will go to rest in 2 weeks' time doesn't mean that it's going to rest forever. It's just been put somewhere. Someday something will happen. Then people will connect their dots, and then we'll come back. So the disagreement, the despondency, the stress will continue. So let's not think that, as you grow, you hear the older people used to say something like, oh, that when the water boils, it will eventually cool. It never cools like that. We've just put it somewhere, waiting. When another matter happens, then we add it. Then it adds. Then the anger builds up. It builds up. Then it causes disaffection. Then you see that eventually the goodwill is eroded, etc. So this Ebeju doesn't work. It has never worked. It was just some kind of analysis that some people give. Today, if you tell me Ebeju, I don't believe so. As long as the matter is in people's mind, they will punish you someday for it. So we need to do all this. Let's get the rulings and read. If we understand everything and agree with the Chief Justice, case closed. If we don't, then the debate will continue into decades and then lead to law reform.
Thank you. Thank you for speaking to us.
You're welcome.
That's lawyer Martin Kpebu, who is a private legal practitioner, of course, an activist when it comes to matters of law, politics, human rights, everywhere. He's interested. He does a lot of activism. I think that's 25 minutes past 8 here in our studios. Of course, we are discussing the statement that came from the presidency, and the interesting part is what I read when it comes to Sandro Kofi Akpafo Olobilekpe